Hi, I'm Ryan Baldwin with Senior Resources and Benefits. I have Craig Riffle here with me today. Craig is an attorney, a CPA, and has been helping his clients for over 30 years with asset protection, including long-term care. And today, we're going to be talking about an article that you had written, How the Pieces Fit Together. Thanks for joining us today.
It's nice to be here. Thank you.
So for those that haven't read the article, can you give us a quick breakdown or review of it?
Yeah, what the article is designed to do is because there are so many terms floating around regarding asset protection, creditor protection, estate planning. In fact, I notice when people make appointments to come in and talk about their case, I may have a variety of different terms on how they refer to it, and the people that are really guilty for creating that kind of confusion are the lawyers. I mean, we refer to those terms as if there's some kind of legal connotation to them,
right.
And there really isn't. It's just different terms that have developed over the years, and so the purpose of the article was to provide some clarity as to the different terms and what they really mean. That's what was meant by the article.
Very good. In the article, you talk about like asset protection, creditor protection. What's the difference, or what?
Yeah, truly a true thought in the legal community as to asset protection or creditor protection, that's dealing with someone that wants to protect their assets in the event that they were to get sued for some reason. Now, Ryan, people come in all the time and they're like, well, I don't owe anybody any money, I don't have a creditor issue. And I ask them, do you drive a car? You have a potential creditor issue. If you think about it for just a minute, people that own assets are targets, and a lot of people will try to mitigate that through insurance, which I'm not saying insurance is a bad thing. I'm not discouraging anybody from carrying insurance, but it doesn't always cover the problem. I was in the car the other day. I do a lot of traveling, and I was in the car and I was listening to this talk radio show.
Oh, yeah.
And they asked the question for the audience was, how are you going to change your social standing in life? And the top three answers, in no particular order, was win the lottery, inherit money, or sue somebody.
Yeah.
And you didn't hear answers like work hard, save money, those type of answers. You heard those three. Win the lottery, inherit money, or sue somebody. And unfortunately, that's the kind of society we live in. It's a very litigious society. And so the purpose of what asset protection planning and creditor protection planning, I'll tell you what it's not.
Okay.
What it's not is it's not hiding your assets or lying to your creditors or stuff like that. I mean, that can get you obviously into trouble.
Get you some more legal issues than what.
What it is, the concept of asset protection or creditor protection planning is to order your estate and hold those assets in such a way that they're not available to pay or to be able to be accessed by that person that wants to change their social standing in life by suing somebody. And so that's what it's all about.
Okay, and is that different than the estate planning with long-term care, or does that kind of tie into it?
There's two other types of two other groups of terms that you kind of get into, and one of them that's a group that's very closely associated by people to asset protection planning is long-term care or Medicaid planning.
Right.
People all the time will come in and say, I want to talk about asset protection planning. And I guess in a true sense, and they really come in and they're talking about protecting their assets from long-term care. And I guess in a true sense that they're right, that is protecting the assets.
Yeah, absolutely.
But long-term care planning or Medicaid planning really is more focused on protecting assets, protecting the family, the individual, if the individual needs some kind of care. And we've talked on previous programs about the fact 1 out of every 2 people need some kind of care. It's a real threat. Absolutely. And the cost of that care is astronomically expensive. So what they're wanting to do with those type of situations is make sure their assets are held or their planning is done in order to protect those assets. Now, I'll tell you again what it's not. Okay. It's not hiding assets. It's not lying to Medicaid agencies. I mean, in long-term care planning or Medicaid planning, what happens is the planner goes through and uses the rules to the advantage of the applicant. Okay. And in the application, we disclose everything. This is what they had, this is what we told them to do with it, but most importantly, here's the rule that says we can do that. Okay. Because agencies are not, what I found over the years, they're not there to try to qualify people for Medicaid benefits. In fact, they've stated it before, they view their job as to try to restrict the payment of those benefits. Now, that's
Right.
really not their job. Their job is just to administer the law.
Right.
But that's kind of their perception. And with that perception, individuals need someone in their corner
Sure.
to help use the rules to their advantage, because the agencies aren't going to do it.
No, they want to do it. Now, you talked about the planning. Does the planning cover state to state, or does it just specific to Oklahoma where we reside?
That's a
or?
good question. I mean, regarding long-term care planning, there's an overlay of federal rules.
Okay.
And then there's some rules that are delegated to the states. And so the way we typically do planning is we follow the federal rules and guidelines. That way they will be applicable to every state.
Okay.
Our concern being is what happens if someone does their planning in Oklahoma, but then they transfer to another state.
Sure.
Well, that way the planning would still follow them and it'd be okay. If we were using state rules, then it wouldn't necessarily be applicable there.
Okay.
On the asset protection or creditor protection side, those are more state specific. I mean, you have
Okay.
to kind of look at the states that they're living in or they expect to be in. Now, I will tell you that in many of those concepts, states have followed uniform acts, meaning that there's an act that was passed and it's pretty much been adopted, not exactly verbatim, but pretty close. So those concepts are pretty consistent from state to state.
Okay.
But it's a little more state specific than long-term care. Long-term care, by using the federal rules, can be nationalized, if you will.
Okay.
And those are totally different than estate planning.
Yeah, that makes sense. In the article, you kind of talked a little bit more about on the estate planning. There's a bunch of different, I don't want to say contracts, but other legal documents like, you have the will, you have a trust, you have, the advanced directive for healthcare. Can you give us like a quick breakdown of what those
Sure.
are? I get so confused.
Well,
on
in
those.
estate planning, let's talk a little bit about what estate planning, is really meant by that. I mean, traditionally, attorneys have meant by estate planning is looking at an individual's estate, their assets, an estate. Some people think of an estate as it's a big flowery word that means somebody with a lot of assets.
That's what I would think.
It doesn't mean that at all. I mean, estate planning can deal from someone that's got very little to very much. And estate planning isn't dealing with just the assets, it's dealing with the whole family, protecting the family, making sure they're taken care of, and that's where some of those concepts come from.
Okay.
So estate planning in its traditional sense really focuses around the individual using a will or a trust. That's something else that people run into is you mention trust to some people and they're like, oh, I don't have enough money for a trust. The type of trust a person may use may depend upon the amount of assets they have. But whether they want to use it, whether they need a trust or feel like they want to use a trust depends upon whether they want to go through the probate process. And in a nutshell, probate is simply a mechanism. The first document we had was a will to pass assets. But a will doesn't mean anything until it goes through a probate court and a probate court says it does. It doesn't mean any more than my notes here that I've got
Okay.
sitting on the table. So it has to go through that process, and the goal of probate is to get the final order that says the person died, these were their assets, the debts have been paid, and the court says, I hereby order transfer those assets to wherever they go. Well, someone at some point in history thought, is there a better way? Because that can take several months and several thousands of dollars to go through. And that was the advent of a trust. And so whether someone wants to use a trust or not, it really is dependent upon whether they want to avoid probate or not. But estate planning is really focused around that concept. But there's two other concepts that you alluded to, and that's the power of attorney and the advanced directive. That's what you're referring to, right?
Right, yes.
Yeah, the power of attorney doesn't, think of it this way. I'm married. My wife's name is Katrisa. And let's say that during my lifetime, I'm incapacitated for some reason. I'm not deceased, but I can't make decisions anymore. I'm still alive, but I can't make decisions. Well, my wife has one or two options to be able to handle those. She can't handle those just because we're married. That doesn't give her, it doesn't give her the legal right to do that. Or my kids. It doesn't give my kids the legal, I've got two kids, it doesn't give them the ability to do that either. So there's one or two mechanisms they have to have. One is they can have what's referred to as a durable power of attorney, which it's a document in which I say, okay, if I can't make, and in Oklahoma it's for financial decisions. Every state's a little different, but in Oklahoma it's really now for financial decisions. If I can't make those decisions myself, then I am delegating my wife to do that for me, or my kids, or whoever I want. It doesn't have to be a relative. Now, if they don't have that document, the alternative is they have to go through a court supervised guardianship.
A guardianship.
Yeah, and you don't want that.
I've heard that that's challenging.
It's challenging. It's very time consuming. A guardianship entails that she would have to petition the court to have me declared incapacitated, which is not a very pleasant proceeding anyway. She has to file an inventory of my assets. If she's successful, she has to file a plan for the care of my person, a plan for the care of my assets, and every year that I'm alive on the anniversary date, she has to update that inventory and those plans and everything. So it can be very time consuming and very expensive.
Wow.
Well, the power of attorney alleviates that. If with a power of attorney, they don't have to go through any of that. And so that's kind of what the power of attorney works in. The advance directive has a couple different parts in it. It has a living will part, which is the part that says if you want to be kept alive or not by life support.
Okay, that's that document.
Yeah, it has that in it, but also has another component, which is in which you appoint a healthcare proxy. And the healthcare proxy is the equivalent of a healthcare power of attorney. It's the person to make the same kind of decisions for me if I'm incapacitated, because again, my wife can't do those, nor can my kids. But I appoint those persons to make those decisions, those healthcare decisions for me, and that's where those are appointed. And so that's the way they work. They're very important documents.
Absolutely.
Sometimes they're not talked about much in estate planning. You know, the focus really, a lot of times in estate planning, really centers more around wills and trusts, but those two documents can be very, very valuable because they can save the family a lot of grief, a lot of time, a lot of money, a lot of expense, and so they can be just as valuable as the other documents.
On the healthcare directive, is that correct?
Advanced directive.
Advanced directive. Is that the one that says like, go ahead and pull the plug if this happens? Because trying to make that decision for a family member, I can't.
You know, you make a real good
that.
point. I'm glad you asked that question because when I first started practicing, I didn't give the advanced directive enough credit. I mean, I could see the difference between having a power of attorney versus a guardianship, but I really didn't see as much benefit on that part of the advanced directive. I'm like, okay, well, they're just making that decision. And then I had a guy come up to me at a seminar about 20 years ago, and he told me, he goes, I don't think you're giving that document enough credit. And I said, okay, well, I'm always learning.
Sure.
Tell me what I'm missing here. And he said his dad had an advanced directive, and his dad had made that decision for the family. Now, there were 4 kids. He had a brother and 2 sisters, so there's 2 boys and 2 girls. And he said, although we knew Dad's decision and what he wanted, he had articulated it all during his life. When it came down to that point to actually make that decision, I don't know that we could have done it, but Dad had done it. And what he told me is he said, we feel, even today, they feel a little bit of guilt, but they knew Dad made the decision. And it really enlightened me on the standpoint of what that document's really to do. That's to take those loved ones out of that position.
Yeah.
You know, I think personally, my personal feeling is I think it's a little selfish if you know you can make that decision not to go ahead and take them out of that position and make it yourself. Now, the other thing too, some people think in advanced directive, if they're signing it, they're saying they want to be disconnected from life supports. You can say in the advanced directive, I want to receive everything.
Give me everything you get.
Everything you can. Yeah, I mean, they think they think if you don't sign it, they get everything they want. But if you do sign it, you're just telling them, and it could be the other way. You can say. But the important thing about the advanced directive is letting people know these are my desires and making that very difficult decision yourself and not leaving it on the shoulders of your loved ones.
Well, yeah, Craig, thank you so much for going through that. That really helps me understand those documents. And we are out of time, but thank you for coming in today, and thanks for watching, guys.
Thank you very much.